General Yoweri Kaguta Museveni nakolajjo twalabye nga yatadde omukono ku tteeka lya UPDF amendment bill lyakisibwa parliament kyejjuzi ekkirizibwe okuwozesa abantu ba bulijjo era ne babawo ebifaananyi ebyafulumya ebyenjawulo ebiraga nti bw'osangibwa nabyo guba musango gwa naggomera kagenda kuba kakujjuutuka. Kati nno General Museveni oluvannyuma lw'okukola ekyo ate n'ebigambo bijja bagidde bisobye.
As you rightly said, that on the 31st of January this year, the Supreme Court ruled in a matter that was on appeal as a constitutional appeal. I filed a constitutional petition back in 2016 challenging the trial of civilians in the court-martial, challenging the establishment of the GCM as a court of judicature, but also asking the court to interrogate whether an accused person can get a fair hearing in the GCM in accordance with Article 28 of our Constitution. So, in the Constitutional Court, I won the petition. The government, through the Attorney General, appealed the ruling, the judgment of the Constitutional Court. And fortunately for me, the Supreme Court also agreed with the Constitutional Court to the effect that a trial of civilians before the GCM is unconstitutional, that the composition and structure of the GCM would not afford an accused person, either a civilian or even serving officer, a fair trial. But also that the GCM itself is not a constitutional court. Unfortunately,
Nozawulira General Museveni engeri gy'amenyaamu amateeka ye ngalowooza nti nno wa kitalo kubanga ye president. Kooti yalagira nti kooti y'amagye teriiwo mu mateeka tekkirizibwa tekkirizibwa kubanga bwemanyi muno parliament yekola amateeka naye nga amanyi nti waliwo maatha ssemateeka atakkiriza kooti y'amagye okitegedde era mwe yagaanira General Museveni olwakafuba bbirigo kaalina n'asalawo n'akola bye yakoze kalina musetuse ku nnyonyi.
As we speak today, Parliament has already passed amendments to the UPDF Act, reintroducing the same structure that the Supreme Court found unconstitutional. So, as it was then, Parliament is still misinterpreting and misunderstanding the judgment of the Supreme Court. For example, in that judgment, it was clearly stated that trying civilians in the GCM is unconstitutional. Now, first and foremost, you cannot amend the Constitution by simply amending an act. So, by amending the UPDF Act and in reintroducing trial of civilians would not change the fact that it is still unconstitutional.
So it was a constitutional amendment?
Yeah. Secondly, the Constitution itself, under Article 129D in particular, says that Parliament may establish a subordinate court. By saying that Parliament may establish a subordinate court, the same article clearly states that we have the Supreme Court, the Court of Appeal, and High Court. So anything that may be established would definitely be subordinate to those courts of judicature. Now, to say that the GCM can try offenses like murder, aggravated robbery, and all such cases would be to give it original jurisdiction over matters which the High Court ordinarily has jurisdiction. So to give it the same would be to equate it at the level of a High Court. Besides, in the same amendments, they propose that appeals from the GCM straight away go to the Court of Appeal, Now, ordinarily, what Parliament has done is to establish another court that is at the level of a high court, something which is still unconstitutional. The only thing that Parliament could do is to establish a division of the high court, not to establish a new court with the same powers as the high court. If, in any case, Parliament feels that the legally established court structure may not able to handle these crimes, then the right thing to do would be to form a high court division, a division of the high court that is specifically charged with the responsibility of handling such cases.
Awo General Museveni esi ayagala buyinza aberenga amaje galina obuyinza yokola byayagala okutulugunya okutta okukola biki n'asaba abantu myaka 5 nga tewali amugambako n'amaana abagamba nti mukize nno mwalina emisango naye nga talina bujulizi bwaleese nno baalina emisango naye nga ayagala just bakkirize bukkiriza. Tasobola kikola mu kooti ndala yonna, alina kikozesa kooti y'amagye gyalina okakkiramu abantu beeweeko obujulizi nti no twalina emisango naye batute bannange oluvannyuma lw'okubasiba ebbanga eddene yokka gy'asobola okukozesa egyo emizannyo. Kati tasobola kuteekawo kooti y'amateeka ekozesa amateeka kuba tejja bikkiriza, alina kukozesa bino bikangalu bye naye ate nno gye binaggwe.
Instead of going ahead to flout the same constitution, we are just moving in circles. Okay? Now, looking at the Constitution under Article 210, Article 210 clearly says that Parliament shall establish a law to regulate the Uganda People's Defence Forces, and in particular, so pursuant to that, Parliament enacted the UPDF Act. But if you look at the constitutional provisions under 210A, 210A is to the effect that Parliament should regulate the structures and organs of the UPDF. In B, Parliament should handle the recruitment, promotion, discipline, and removal of members of the Uganda People's Defence Forces. The Constitution is clear. Recruitment, promotion, discipline, and removal of members of the Uganda People's Defence Forces. And in C, it says terms and conditions of service. D, it says deployment of troops outside Uganda. Nowhere under that article does Parliament get the mandate to establish a court of law. Under discipline, what I would envisage, or what Parliament should have done, is to provide for disciplinary tribunals under the UPDF Act to discipline serving UPDF officers and men, but only to the extent of service offences, not criminal matters, because we have a clear and elaborate system that can deal with any incidental crime.
Immediately after the ruling, the Attorney General was quick to advise, and the advice was maintained even up to the passing of the UPDF Amendment Bill, that the Supreme Court did not nullify the establishment of the GCM, but rather the trial of civilians. So it looks like in your submission you're faulting Parliament, but how about the Attorney General?
You see, the Attorney General, unfortunately, in this matter, has been...
Kachobomanya, Attorney General, takola ku mateeka nga ogenda kutambula, ye akolera ku biragiro bya General Museveni. General Museveni kyayagala, kyamulagidde nti kiri wakiwanuka njagala kino kyakola. N'abalaba nga amateeka ge bakikoleramu mafu, tajja kugaana kuba gwe mulimo gwalina oguprotectinga ng'akola boss we kyamwetaaza. Kati oyo Attorney tutanza kumukootinga anywhere kubanga ye byakola si byagoberera amateeka. Yakola bisanyusa mukama we biragiro, akolera ku biragiro. Tula beetagawo court martial ekolera ku biragiro, so si ekolera ku mateeka. Bo beetaaga just bateeke biragiro nga balagira bulagizi nti do this nekikolebwa, do this nekikolebwa, basibe ne babasiba, batte ne babatta, myaka 10 ne babasiba myaka 10. Just bo beetaaga order.
I found wanting because the ruling was very clear. that it affected both civilians as well as. Now, if the Supreme Court says that his establishment that its position that the qualification of its members is unconstitutional, then how can it exist? If someone says that it is not capable of giving anyone a fair hearing under the way it is composed, how can it then be in existence? Clearly, the Supreme Court says this GCM is not there. It is unconstitutional. It was buried, and it was so ordered that all files pending be transferred to the. What does that mean? If the Supreme Court orders that all matters that you're handling currently seize and transfer them, what does it mean? It means that you are not there legally. So they were declared unconstitutional, and they did not exist from the point of the ruling. To date, we do not have the GCM in the laws of Uganda. It doesn't exist. And it is very unfortunate that Uganda Prison Service continues to hold so many people who were sent to them by the defunct GCM. Because under the laws of Uganda, Uganda prisons cannot admit an inmate without a valid remand warrant. So at the time when the GCM was declared unconstitutional and illegal, it means all such documents issued by the defunct GCM were declared a nullity. So right now we have people in prison held by Uganda Prison Service illegally and unconstitutionally.
When they say that it is a process of transferring the files as ordered by the Supreme Court, what do you have to say about it?
Of course, we understand that it is a process, but a process cannot take 6 to 7 months. So, a process should not infringe on the rights of suspects if you have any cases against them. I advise at some point that what government could have done was to release these people, rearrest them if they have evidence, fresh files compiled, and the matters put before the magistrates' courts or the right courts, instead of continuing to hold these people illegally. For example, if I had been detained by the General Court Martial because I am suspected to have been found in possession of a gun, Uganda prisons should have set me free. Then police would be, police would be at liberty to rearrest me, put me in their custody, make the file if they have any evidence, and produce me in court to be formally charged instead of being held incommunicado. Because these people are held in the prisons without any valid papers, but without any knowledge of what happens next. Because these guys have been on remand for now, since January, this is about 5 months, and nobody seems to know their fate. They have no charges or pending charges before any competent court in this country, but they continue to be held. And this is an infringement on their rights. And so we should continue advocating for their release. Or if they have any evidence, let them take them before duly constituted courts of jurisdiction.
From the time you petitioned the court, you won and then Attorney General appealed.
Whatever we say, in whatever we do, in whatever we admire, we must do one thing. The real problem we have in Uganda is General Museveni. Nobody else. General Museveni is the problem we have. And that's the one guy, the only guy we must fight, we must stop in Uganda. if we can't stop General Museveni, bino byonna bijja kusigala nga weebiri. Tujjanga kubyogerako, tujjanga kubinyumyako, tujja kwogera kino, tujja kwogera kiri, naye nga Guy ayongera okugenda mu maaso n'okukola ebikolobero ku bannayuganda, ku baana b'abandi abatalina musango, batalina kye baali bamukoze. Nolwekyo okustopinga bino, okugjawo bino, tulina kugjawo General Museveni yennyini. Bino tebijja kuddamu kubeerawo. Tujja kuba ne gavumenti zigoberera amateeka nga zimanyi nno constitution egamba kino era tulina kukola kino. Lwaki otekawo ekkooti ey'enjawulo gwe gy'onoowa ebiragiro n'ogaana okugoberera ziri ekkooti enkulu eziriwo. Gwe otekawo ekkooti eyiye enkulu era obuuza bwe bunene ekkooti enkulu kiba kitegeeza ki ekyo? Kwemyereza mbuzi na kutulugunya bannansi.
And the time the Supreme Court pronounced itself, do you in any way have any spirit of the period that this ruling came in, especially now that we have the retired Colonel Dr. Kizabesi in prison, we are heading to elections? Are you bothered of the period, of the time?
Of course, I know that hitherto the GCM has purely been used as a tool of political suppression. The GCM has been used purely to frustrate and oppress people who have a different political ideology or different political feelings from different from the ruling establishment. If you really look into the reasoning that Mr. Museveni relies on to justify why we should have a GCM, one is that it is capable of fighting gun crime. Now, from my experience and going by what is happening in the country, the GCM is not doing that. We know, for example, recently that there were some people who were convicted of murdering the late Joan Kagezi. Now, these people did not use stones, neither did they use spears, but they used guns. And those people were tried before the civil courts.
Why not in the military courts?
Found guilty and convicted. About 3 or so months ago, a young man in Ntinda here was killed. Albert, a mobile money operator, was
Brother
killed.
to Doreen Nyanjura.
Yes, a brother to the Deputy Lord Mayor of Kampala, Nyanjura Doreen, was murdered by gun-wielding thugs. Now, the same appeared before the civil courts. We have had so many incidents here. Mole Katanga, who is suspected of having shot and killed her husband. We have the 2010 suicide bombers. We have Jamiru Mukulu here, the suspected leader of the ADF. All who used what would ordinarily be termed as weapons, the monopoly of the, which are supposed to be the monopoly of the UPDF. Now, all these cases I am talking about have been tried by the civil courts. And that clearly shows that the civil courts are very competent to handle these matters. Now, on the contrary, what you find in the GCM are people who are found with a beret that resembles that of the UPDF. The likes of Yasina Shepe, Bobby Young, Olivia Lutaya, and the others. Those are the people who are before the GCM. Now, what is in common? They are all political opponents. You have Dr. BSJ, who was arrested, who was actually not arrested, who was kidnapped and renditioned, extrajudicial rendition to Uganda. Tried before the GCM. So, in a situation where people with guns, people who are murdering and pillaging with guns are being tried by the civil courts.
And those without guns?
People of different political opinions
with a ballet?
Before the GCM. I have no doubt whatsoever in my mind that the GCM is established solely to oppress the political opposition.
Wow, what a submission. So kawejjukanyemu abataka Kagezi omulamuzi nga bakozesa emmundu lwaki bo baweesa mu kooti za bulijjo okitegeera lwaki abatta mujjukira batugamba nti no be batta ono omusajja yali omwogezi wa poliisi mujjukira erinnya limbuze yali omwavu yali omwogezi wa poliisi yani maama Kaweesi abaamutta tebabatwala mu kooti masho babatwala mu kooti ya bulijjo abatta kirumira bwe wamu lwaki abatta n'emmundu tebatwalibwa mu kooti masho nebatwalibwa mu kooti ya bulijjo kubanga baba baabwe lwaki abambadde just akakofiira aboogedde just ebigambo nti notwaga kujjako Museveni bo batwalibwa mu kooti masho kubanga bo baagala buyinza bali batta kubanga babatumye batte naye bano bo baagala buyinza naye nga tebalina gwe basse enjawulo eriwo kati tulemeseza tutya abaagala obuyinza kubanga baagala buyinza tulina kukozesa magye tubalemesa okutwala obuyinza bwaffe naye oli ate mudde n'emmundu kubanga ffe tumutumye tujja mutwala muziri kooti just basibe yaawo.
Now, moving into the 2026 election period, there is no way Mr. Museveni envisages an election in which he does not have a scarecrow. Because hitherto, the GCM has been used as a scarecrow. He doesn't envisage a scenario where he walks into an election without his scarecrow. Because that is what he uses to silence so many dissenting voices, genuine dissenting voices. So purely that is politics. It has nothing to do with crime or criminality.
As someone who carried the flag to the Supreme Court and so on, what is the way forward now that the status quo has been maintained?
Well, as I said, I'm still of the opinion that whatever Parliament has done was not born out of reason and posterity. It was born out of what was on offer. These MPs were simply on the stalls. They were up for grabs. So Mr. Museveni, because he knows he's going into politics, bought them off, bribed them to do the wrong thing. They know what is right. But this was a transaction. Whatever amendments they have done were transactional amendments that are purposely being prepared for the 2026 election. Now, on the other hand, I am very alive to the fact that whatever amendments have been made, especially those relating to the GCM, not the bill is faulty, by the way, and I need to make this very clear, that there are aspects of the bill that I agree with, but the part relating to the GCM, I am fully opposed to it, and I will be going back to the courts of law to challenge it again. I am going back to court to challenge those illegal and unconstitutional provisions that they have reintroduced in the amendment bill. So as soon as the president assents to that, I will be filing a petition to challenge them. Yes.
When the president comes out to praise Parliament for his last speech during the State of Nation address, said UPDF is not a company. Why do you people want to treat UPDF as a company?
Of course, you see, when he praises them, he is only celebrating that he got a positive return on investment, because he invested quite a lot financially into that project. So the fact that they told his line clearly for him is worth celebrating, because his money has given him a return. So he does not look at what is good for this country. He is not looking at this country. He's not looking at me and you. He is looking at what it takes for him to hang on, to stay in power. So that is what he's celebrating. He's not celebrating that the law has, that the country has made any achievement. No. That is not the Mr. Museveni that I saw swearing in 1995 to uphold the constitution. No.
So should we summarize that the projected law is a bad law to the country?
Yes.
Without any doubt. Bad may be fair to the... I wish there was something better than that I could use. Yes.
Thank you very much, Honorable, for this insight.
Wow, that was good. Here we go. Museveni sawa yonna bamuzeeyo mu kooti alina okiyinza okumaliza nga akwatiddwa lwaki kuba webinaggwera okuwoza omusango kati omupya ogenda okuwabibwa olwaleero ajja kuba takyali president wa Uganda, ajja kuba takyali mu ntebe, meaning ejja kuba just order of arrest